Welcome everyone. My name is Carolina and I'm the founder at Girls in Aerospace. Thank you everyone so much for attending this Space Law webinar. We're going to get started shortly, but first I would love to introduce our socials as well as Lauren's socials that you can stay in touch with us after this webinar ends. Girls in Aerospace is a global nonprofit, and we host monthly events such as this one where you can meet aerospace engineers, astronauts, and astrophysicists in either a workshop or a webinar form. And apart from that, we also run a number of other programs, including an international digital magazine and more. All of our events can be found on our website at girlsinaerospace.org, and we post regular updates on our Instagram at Girls in Aerospace. We're so lucky to have Lauren here. Lauren's a space law communicator, and she's going to talk us through space law and the Artemis Accords. I'll let Lauren give a more detailed bio of herself, but make sure you check out her Instagram at spacecodehacker and her website, spacecodehacker.com. And with that, Lauren, take it away.
Thank you so much, Carolina. I'm Lauren Killam, and I'm so excited to be here. I'm just going to go ahead and share my screen, and we'll get started. Okay, so welcome to my webinar on space law. And today I'm going to be introducing you to the current relevant space law for the Artemis generation. And because we're going to see the first woman and the next man go back to the moon. And I just wanted to share everything about that with you. And I'm so excited to be here. So thank you so much. We are going to get started by I'm going to get started by introducing myself. So my name is Lauren Killam, and I am an emerging space law communicator. My dream is to become a lawyer who specializes in space law, but because of various world issues at the moment, I've had to push pause on my academic career. So I have decided to share what I've been learning about space law in a less formal setting. And so here I am, and I'm so thrilled to be here. So, okay, I have a background in applied mathematics and anthropology, and my future plans are to study law and policy. I'm a mom. I'm a former World Cup snowboarder. I have lots of other interests that mostly focus around the outdoors. Yeah, so that's a bit about me. Now we're going to shift gears and talk about what we're going to be learning about. So we're going to start off by introducing space law. We're going to define it. We're going to learn a little bit about its history. We're going to talk about legal sources of space law. Then we're really going to dive into the Outer Space Treaty, and we're going to discuss some notable issues with it. Then we're going to switch gears, and we're going to talk about NASA's Artemis program, which is really exciting. And we're also going to talk about NASA's Artemis Accords. And this is where we're really going to spend the meat of time, like the most amount of time in this presentation, because this is the part where that I think is really exciting. And then we're going to use what we've learned in those two different sections to talk about some future issues that I think may become very important in the next few years. Okay, so first I want to say thank you so much to Carolina and the Girls in Aerospace team for having me. I'm so thrilled to be here, to be able to do this, to share with you about space law, because I'm very passionate about this subject, and my husband's very supportive, but he's really excited that I've got other people to talk to about this. And then I also want to say thank you to Andreas Kodletz and Lauren Peterson for reviewing the content of this presentation, this webinar. And I also want to say thank you to Ariana and Zara, whom you can find on Astronaut Ariana and Astronaut Zara, who you can find on Instagram. You can also find Lauren Peterson on Instagram at LP_InSpace. And I want to say thank you so much to my wonderful space community for all of their support with this. So thank you so much. I'm so happy to be here. Okay, let's get started. And I'm going to start off by defining what space law is. And the most, I would say, commonly accepted definition is provided by the United Nations Office for Outer Space Affairs. And they say that space law is the body of law governing space-related activities. And that's a great definition, but the one that I actually prefer is by Frans van der Donk, and he's a very well-respected expert in the space law world who's currently teaching at a US university, I'm pretty sure. And he says that space law is all law that actually, one way or another, follows humans into outer space. And the reason that I like this definition is because it really emphasizes that all of the issues that we experience here on Earth, we will likely encounter as we continue pushing the boundaries of space exploration and hopefully one day even human space settlement. So this definition, I think, is really important and really opens up our minds to what will become important in the future. And one thing that I want you to notice is that both definitions kind of presume that outer space is a separate geographical area. And this doesn't necessarily come from the definition, but one thing that I have noticed as I've been reading about space law is that it is assumed to not have any frontiers, except for that undefined lower boundary. And it's interesting because that lower boundary is currently officially undefined. So there we go. And it is considered to be separate from airspace. Okay, so the law never seeks to regulate technology, but rather aims to place order in the competing human interests that result from that technology. And this is a quote from a textbook that I love by Lyle and Larson. And this quote, I think, is such an important one for us to be thinking about, because when we are thinking about technology and when we're thinking about laws and regulations, we're not necessarily restricting the technology itself. We're more talking about the human competitiveness and the human interests that change because of new access to that technology. And I think that this is something really relevant to keep in the back of our minds as we're learning about space law and as we're continuing to push the boundaries of space exploration. And there is one question that I want you to keep in mind as you're learning, and that is, do you think that we should manage space technology on a global basis? So this is not necessarily a question that we're going to answer right now, but this is a question that I want you to think about as we're learning. So let's switch gears and learn about the history of space law. Space law first appeared as a legal category in 1926. It came up in a Soviet paper that talked about needing the need to manage the area beyond airspace separately. And this is really cool that this was happening at this time, because this is like years, decades before humans were really thinking about launching rockets. And in 1929, a German academic suggested that the atmosphere is the upper limit of a state's sovereignty. And this is very important too, and we'll learn more about this later. And in 1932, a Czechoslovakian academic, he wrote about lots of different things to do with space law, including legal matters like freedom and negligence, liability, continued ownership of spacecraft, and he even went so far as to mention that in the case of human space settlement, it may at some point become necessary to change nationalities, which is really big and really exciting that like people's minds were already going there. And one thing that I do want to mention is that this is a time when science fiction novels were becoming very, very popular, and not just novels, film as well. This is kind of like the first, in this period of like the 30s, 40s, 50s is when we really started to see a lot of interest in the artistic realm about space, which I think is fantastic. And we saw writers like H.G. Wells, Arthur C. Clarke, Isaac Asimov become very, very popular in around that same kind of time period. And I think that's really interesting and notable that there was a lot of excitement, very similar to now, actually. And so on a more formal level, we saw the establishment of the International Astronautical Federation in 1950. And then in 1958, they went and created a permanent legal committee. Now, those of you who know a little bit about space history, this might ring a bell for you. And if you don't know about space history, well, this in 1957, that was the year that Yuri Gagarin made it to space. The first human made it to space. And all of a sudden, people realized that space law is something that was going to become very, very important very quickly. So there we go. And that permanent legal committee, it actually became the International Institute of Space Law, which is still the most important international institute for space law that is currently still working and producing wonderful documents. But as you can see, there are lots of other institutes for space law. And if you go to my website, spacecodehacker.com, you can find out more information about what kind of space law institutions and programs are currently available. And if you do go to my website and you do look at that list and you know of an institution or a program that's not listed, please let me know and I'll add it. And also too, I think that there are institutions from South Africa and India, but I couldn't find their websites. So like I said, if you know of them, please let me know, because I would like to be able to expand this list beyond Europe and North America. Okay, space law history. So a brief history of the United Nations Committee on the Peaceful Uses of Outer Space. So this committee, it was formed in 1958 and it became permanent in 1959, again, because of the Russians making it to space for the first time. They submit annual reports to the United Nations General Assembly, and they have two subcommittees, one that is the Scientific and Technical Subcommittee, and the other that is the Legal Subcommittee. And these reports are quite often turned into resolutions, or not quite often, but they are used to create resolutions that are passed by the UN General Assembly. So that's pretty cool. And this committee, they started out with 18 members. And as of 2019, the committee membership has expanded to 95 members, which is huge. And the reason that they expanded the committee membership so much was to have better representation, both in terms of representing developing countries and larger geographical regions, which I think is fantastic. This is, I would say, like the first time that we've really seen a big push in to make space more diverse. So that would be called the diversification of space, which is increasing representation in space, which I think is hugely important. I mean, if you look to the right side of your screen, you'll see that there's a picture of, you know, a whole bunch of men, old white men. And this next picture is what the Committee on the Peaceful Uses of Outer Space looks like now. I'm like, how amazing is this? So even though a lot of space law experts say that the committee has become less effective because it's now so big, it does take a longer amount of time to produce decisions and documents and positions on certain matters. And they also say that there have been some issues with delegates sending representatives who don't necessarily have authority to make decisions, or maybe don't know what they need to know. But I think that even though there are these issues, this is such an important initiative. And I think that, I mean, we can find a way to move forward and make this committee more effective, while also staying committed to diversifying, which I think is something that's hugely important. So I love the difference between those two pictures personally. And I think this is a huge success. Okay, let's continue moving on. When the Committee on the Peaceful Uses of Outer Space was formed, it reported to the United Nations Department of Political and Security Council Affairs. But very quickly, they realized that space is going to become really important and actually needed to have its own division. So that service group was renamed the Outer Space Affairs Division, and was later renamed to the Office for Outer Space Affairs. And the United Nations Office for Outer Space Affairs is still doing some very important work, and I would highly recommend checking out their website. They have so many amazing sources of information there, including all of the treaties and principles and resolutions that are just available for anyone to read in several different languages, which is fantastic. The Office for Outer Space Affairs is responsible for maintaining the register of space objects, as well as databases, other documentation, and they also produce education recommendations as well for institutes that are wanting to incorporate space law into their offerings, which I think is really important and super cool. And they have two sections, space applications and committee services research. Moving on to sources. So where does space law come from? Well, you probably think of big international treaties as the first thing that pops into your mind, or maybe UN resolutions. Another common idea when you think of domestic space law is domestic space law. And an example of that would be the 2015 Commercial Space Launch Competitiveness Act that basically has spurred the big rush for the commercialization of space in the US, which I think is, again, really amazing. And we see that, like, all these wonderful companies in the US that are really pushing and doing some fantastic new things that we've never seen before, like, you know, like the Crew Dragon, and whew, so awesome. So yes, very exciting things are happening. But there are also less formal sources of space law, such as memorandums of understanding, working arrangements, informal standards, resolutions, procedures, reports that are generated by less formal organizations, but that are still very important. And then there's also just international custom. And the question that I want you to ask yourself when you're looking at these sources and thinking about them is, which of these sources are legally binding and which are not? Well, UN treaties are generally considered to be legally binding, although we'll discuss more about that later. And then UN resolutions are typically not considered to be legally binding. And this has been emphasized by the International Court of Justice on numerous occasions. So it's interesting to think about as well. Domestic space law is legally binding, but only in that region, only in that area. And then there are also, like, some contracts are legally binding, but again, how is that enforced? That's always something to consider when you're reading about space law, that I find very interesting. And if you are curious and want to know more, you can check out the different links and sources that I've posted. And then on the right side of your screen, you see a list of the 5 UN treaties and also the 5 UN resolutions. And what I want you to notice or know is that the UN resolutions are basically expansions of certain principles that are found in the various treaties. And before we dive into the Outer Space Treaty, which we're going to examine carefully, I want you to focus for a moment on the Moon Agreement. The Moon Agreement was introduced in 1979, and it had a clause in it, or a line in it, that said the moon is the heritage of all mankind. And this was originally viewed as sort of something that was like, oh yeah, sure, whatever. But as it would happen, it had a connection to the law of the deep sea, and it suggested that, and by saying that the moon was the heritage of all mankind, it was trying to establish that the moon was a global commons. And when the US and Russia found out about this, they decided that they did not want to sign this treaty. And so none of the major spacefaring nations have signed the Moon Treaty, or the Moon Agreement rather. And this is something that's very, very notable. And we'll discuss more about this later as we get into the Artemis Accords. Okay, moving on. Okay, so now we're going to dive into the Outer Space Treaty. Some quick facts about it. It was first adopted by the UN General Assembly in 1966. It was opened for signature in 1967. It was entered into force later that year. And originally, it was signed by 93 states, ratified by 16, and that represented about 88% of the UN membership. As of January 1st, 2020, the Outer Space Treaty has been ratified by 110 states, and it has been signed by another 23, and that represents roughly 68% of the UN membership. So we want to ask ourselves, why is it that that nations are not really finding the Outer Space Treaty to be something that they want to sign, or something that's valuable for them to sign? So that's a big question that I want you to hold in the back of your mind and sort of start getting curious about. And with that in mind, let's learn a little about the Outer Space Treaty. So the Outer Space Treaty is actually quite a short document, and I would totally recommend that you go and actually read its original text. And what I've done for the purpose of this webinar is I've taken some excerpts that I think are the most important quotes from each of the different articles. And we're going to go through them briefly, and then we're going to discuss some critiques and criticisms that the space law community has put forth after we've reviewed. Okay, so Article 1 is all about the benefit of outer space, and it says that the exploration and use of outer space shall be carried out for the benefit and in the interest of all countries, irrespective of their degree of economic or scientific development, and shall be the province of all, well, they said mankind, but you know they mean humankind. Okay, anyway, appropriation. Article 2, outer space is not subject to national appropriation by claim of sovereignty, by means of use or occupation, or by any other means. These are obviously very important, right? Like, these are big principles. And the purpose of this treaty was to preserve, like, to ensure that peace was, that, you know, when Russia and the US were really pushing to get to the moon, and there was that first big space race, that it would be a peaceful space race. That's like, when you're reading about these principles, I really want you to have that history in the back of your mind. Okay, so Article 3, peace and security. States shall carry on activities in the exploration and use of outer space in accordance with international law and in the interest of maintaining international peace and security and promoting international cooperation and understanding. Article 4, weapons. States undertake not to place in orbit around the Earth any objects carrying nuclear weapons or any other kinds of weapons of mass destruction, install such weapons on celestial bodies, or station them outer space in any other manner. So, no nuclear weapons and no weapons of mass destructions in outer space. The moon and other celestial bodies shall be used by all states exclusively for peaceful purposes. These are really important and really good, right? Astronauts, they shall be regarded as envoys of all humankind, and shall render, and basically all states, like, if they get into trouble, then states parties have to try their best to help them, which is great. And then compliance, states shall bear international responsibility for national activities in outer space, whether they're carried out by governmental agencies or by non-governmental entities. And this is the first, I think the only time that non-governmental entities are mentioned in the Outer Space Treaty, which is something that's noteworthy. And they have to assure that national activities conform with the provisions set forth. And then liability, each state is internationally liable for damage to other states. And then jurisdiction, a state on whose registry an object launched into outer space is carried shall retain jurisdiction and control and of that actual spacecraft and over personnel as well. And this is really important, especially considering that, I mean, people may land in a completely different area from where they launched. Interference and conservation, states shall be guided by the principle of cooperation and mutual assistance, and shall conduct their activities with due regard to the corresponding interests of all other states, and that they shall pursue studies of outer space and conduct explorations so as to avoid their harmful contamination, and also adverse changes in the environment of Earth resulting from the introduction of extraterrestrial matter. Because again, like, they didn't know. I mean, we still don't know what we might find out there. So this is an important thing to know that's in the Outer Space Treaty. Observation, states shall consider on a basis of equality any requests for an opportunity to observe the flight of space objects. Information sharing, in order to promote international cooperation, they agree to inform the UN and the public and the international scientific community of the nature, conduct, locations, and results of activities in outer space. Reciprocity, all stations, installations, equipment, and space vehicles on the moon and other celestial bodies shall be open to representatives of other states on a basis of reciprocity. This is a big one, and I want you to remember this. Partnership. The provisions of this treaty shall apply to the activities of states in the exploration and use of outer space, whether such activities are carried on by a single state or jointly with other states. Logistics. The treaty shall be open to all states for signature, subject to ratification. This is pretty standard. Again, amendments, they can be made. They have to be accepted by a majority. Withdrawal, states can pull out. They have to give notice and then wait for 1 year. Deposition of languages. So there we go, pretty standard. Okay, so now let's discuss the Outer Space Treaty in a little more depth. So let's start off by looking at Article 1. The exploration and use of outer space shall be carried out for the benefit and in the interest of all countries. So what exactly do they mean by the benefit and in the interest of all countries? Like, what does that really mean? And this has become quite a contentious issue, like, because a lot of states think that benefits means one thing and then others say something else. Yeah, so this is something that I find quite interesting. And there was a benefits declaration that was passed in 1996. That's one of the UN resolutions. But when you go to read that, which again, highly recommend, it's basically 2 more pages of similarly vague language. So what, like the definition of benefit and interest in the context of outer space, that has not been defined, which is interesting and notable and something to keep in mind. Okay, outer space is not subject to national appropriation by claim of sovereignty, by means of use or occupation, or by any other means, Article 2. But does it say anything about private companies? And no, it does not. So this doesn't say anything at all about private companies, which is something that's very interesting that we need to acknowledge. So as of right now, according to the Outer Space Treaty, it is technically legal for private companies to make claims in outer space, which is kind of interesting. And so the Arch Mission Foundation, they did launch a lunar lander several years ago. It crash landed. It was carrying a bunch of tardigrades, I think some human DNA and a database, like essentially a library of human knowledge, which I can appreciate is pretty cool. But there is that lunar lander that's up there. And so some space law experts are saying, well, can they make a claim to the area where that lunar lander crashed? And again, technically, yes, which is interesting. And what do you think about that? I would love to hear what you have to think about that. Okay, now moving on to Article 4. States undertake not to place in orbit around the Earth any objects carrying nuclear weapons or any other kinds of weapons of mass destruction. Yeah, but do they say anything about conventional weapons? No, they do not. So technically, conventional weapons are permitted. And it's not well known, but Russian cosmonauts, they have been known to carry survival pistols with them on their missions into outer space. In the 60s, there was an incident where a Soyuz capsule landed really far from where they were supposed to, and it took a lot of time for rescuers to make it to the cosmonauts. And they said that there were some issues with wildlife. And ever since that incident, they started carrying these survival pistols. But this is something that's kind of fascinating that to think of. Like, imagine cosmonauts going to the International Space Station and knowing that they have a gun in their capsule. Like, that's pretty huge. And again, according to the Outer Space Treaty, it's technically allowed. What do you think about that? Okay, the moon and other celestial bodies shall be used by all states exclusively for peaceful purposes. Now, by this time, you must be noticing a theme. What does peaceful purposes really mean? What do they mean by that? Do they mean non-military? Do they mean non-aggressive? One state might think something different than another state. Pardon me, I'm dry. But yeah, that's something that's really interesting. again, notable. So I wonder how that will play out in terms of the moon, right? And I should note that the U.S. typically, it's known that the U.S. has interpreted peaceful purposes to mean non-aggressive, not non-military. And their interpretation of this article in that way has permitted them, is the reason that they have felt it, that it is legal for them to form the U.S. Space Force. So again, and some other countries don't necessarily have that same interpretation of this wording, which is kind of neat. So I wonder how that will play out on an international scale. Okay, and then moving on to Article 9, states shall pursue studies of outer space and conduct exploration of them so as to avoid their harmful contamination. And I know you're totally 100% going to guess it. What does harmful contamination mean? What does it mean? Yeah. So anyway, you might know that there are some big problems, and most of these problems with the Outer Space Treaty, they stem from really ambiguous language. And so I wanted to introduce this concept to you of soft law. And before we do that, I want to ask a question, like, why do you think it might have been useful to use such ambiguous language? And if the language had been less ambiguous and more specific, would it have been more difficult to get the US and Russia to sign the treaty? Maybe, right? So we can see that there may have been a reason to use vague language. But the Organization for Economic Cooperation and Development, and this is a US organization, they have said that there is a body of law called soft law. And soft law is defined as normative provisions contained in non-binding texts that cover those weak provisions of international agreements not entailing obligations. And so some space law experts consider the Outer Space Treaty to be an example of soft law. Others disagree, but this is something that's really notable and important to recognize. So the question that I have for you is, given what you have learned about the vague language that has been used in the Outer Space Treaty, and the position that some experts have taken in thinking of the Outer Space Treaty as soft law, just how legally binding do you think the Outer Space Treaty really is? I would love to hear that, so let me know. Okay, so I also want to draw some attention to missing sections. Like, obviously there are a lot of things that are missing from here, like space resource utilization, orbital debris, private companies, that kind of thing. So there we go. Let's move on. The Artemis program. So NASA's Artemis program is a really big deal. We are going to see the first woman step onto the moon. I'm so excited about this. It's something that I am so thrilled about. And the next man, obviously, which is going to be really exciting. And the purpose of the Artemis program is to build a coalition of partnerships to boost the US space economy. And again, this is from the US perspective. This is because all of these ideas are taken from the Artemis, like the NASA document about the Artemis program. So this is a very US focused perspective. Okay, and so the timeline is very fast. So they want to return to the moon robotically by 2022, which is amazing. And they're going to be sending astronauts to the lunar surface by 2024. Oh my goodness, so exciting. And then the idea is to establish a long-term lunar presence by the end of the decade. Wow, that's so huge. So what are some details? So the very first thing that they're going to do is they're going to set up the technology that they need to get there. That's like the Space Launch System, the Orion spacecraft, which is that capsule that you see there, the exploration ground systems, and the landing system. And then the next phase is sending an uncrewed mission that will see the Orion capsule travel as further past the far side of the moon than anyone has ever gone before. Then in Artemis 2, they're going to do that same thing and go even further with a crewed mission. And then for Artemis 3, astronauts are going to go to the lunar surface, which is just so amazing. And I'm Canadian. I have to say I'm very excited because a Canadian astronaut will be going on the Artemis 2 mission, which is just such a big deal. Oh, amazing. And also in this phase, they will be developing the Lunar Gateway space station. So this is all such a big deal, right? Huge. Oh my goodness. And we get to see this. Oh, how exciting is that? Okay, and then the next phase of the Artemis program is to extend lunar missions to a 1 to 2 month duration, which is amazing. And they say, like in all of the literature, like in all of the program descriptions, that the purpose for doing this is to prepare for going to Mars. Oh my gosh, how wonderful is that? So for this phase of the Artemis program, they are going to be developing a base camp. And in order to do that, they're going to have to develop a lot of infrastructure, such as communications, power, radiation shielding, waste disposal, storage planning, and so much more. And if you want to read more about that, this is a public document that you can just look up on the internet, which is amazing. And I think you should totally do it. It's very exciting to read. Okay, and now let's learn about the Artemis Accords. So the Artemis Accords, they are a set of non-binding principles. And the purpose of them is to maintain peace, to provide a framework for maintaining peace and governing the behavior on the moon. They're going to specifically address activities involving commercial partners. And then it's very important to note that these have been signed by 9 nations, 8 originally, and they were joined by a 9th, and they were signed very recently in October 2020, and then in November 2020. And the countries that have signed the Artemis Accords are Australia, Canada, Italy, Japan, Luxembourg, the UAE, the United Kingdom, the Ukraine, and obviously the United States. And one thing that I want you to notice about all of these nations is that they are natural allies of the US. And I want you to start asking yourself, what is it that all these nations might want, or how might they benefit from establishing a partnership with the US? So keep that in mind. Okay, now we're going to go through all of the different sections of the Artemis Accords. The first one is just about establishing purpose and scope. And basically it says that it limits everything in the Artemis Accords is limited specifically to civil space exploration. So this does not have anything to do with military space exploration, which means that Space Force, the US Space Force, is not, they cannot sign these accords. And the intention behind the Artemis Accords is to promote the sustainable and beneficial use of space for all humankind. And also, it's very important to note that these are non-binding political commitments, and that they are implemented via contractual mechanisms. And they also do mention in numerous ways entities acting on a nation's behalf, which is great because this means that they're really promoting commercialization. And commercialization has been really positively correlated with the democratization of space. And the democratization of space just basically means that they're trying to increase access to space, which is a really big deal and something that I think is just so important. Wouldn't it be wonderful? How wonderful would it be to see that beautiful blue dot below you? And how much would it shift your perspective about life here on Earth, right? So that happens when we increase access to space, and commercialization is a big part of that. So, all right. And the Artemis Accords support it in numerous ways, which we'll see. Okay, implementation. So basically this section is all about the requirements that should be included in legal agreements. And this is great. This is basically providing a really clear framework for how to proceed with legal arrangements. And they say that legal arrangements should have protection for liability, intellectual property, and the transfer of goods and technical data. And that all entities that are acting on a signatory's behalf, they must comply with the principles in these accords. And this is just so important because this is, again, making sure that all commercial entities, companies, that they have to comply with the principles set out in these agreements, which they've never been held accountable. Like, they've never been involved in agreements before. So this is a really big deal, and I like to see this a lot. Okay, peaceful purposes. Now, when I first went to read the Artemis Accords, and I read through the table of contents and I saw peaceful purposes on there, I was like, oh, they're going to define what peaceful purposes actually means. Like, yes, they're gonna strike out the ambiguity, but nope, they have not. So it's still very vague. They affirm that these activities should be exclusively for peaceful purposes, though they don't say what that means. And because they don't explicitly say that peaceful purposes means non-military activities, that these accords are basically supporting the US idea that peaceful purposes means non-aggressive. Yeah, so military activities are not exclusively prohibited, though these accords are limited to civil space exploration. Section 4 just basically supports the Outer Space Treaty. Section 5, interoperability. This is kind of a cool one. It basically means that as different nations are developing technology, that they should try to be able to fit together. So we don't have a kind of situation where we have like an Apple plug that doesn't work with anything else. So they want different technologies to be able to actually work together. So I think this section's really cool, and not something that I had ever considered to be a really big issue, but I can see it would totally be a really big, important issue. So I think that this is a really good, really great section to have in place. Emergency assistance. Again, this is pretty much just affirming support for the Outer Space Treaty, Article 5, and the Rescue and Return Agreement, which is one of the UN resolutions. And then Section 7 is the registration of space objects. And this is just, again, like affirming the Registration Convention, which is one of the, is that a treaty or a resolution? I can't remember. Anyway, and the cool thing about this is that they just tweak it a little bit to basically say that that all signatories, they have to consult with non-parties. So, and you can read between the lines and know that this is talking about commercial operators to determine the appropriate means of registration. So again, really just making sure that they're accounting for commercial entities being part of these programs, which is great. Moving on to the release of scientific data. The Outer Space Treaty only requires states to inform the international community to the, quote, greatest extent feasible and practicable. And again, that basically provides like so much leeway. And so this section is really all about encouraging signatory states to share scientific data. It does allow for the protection of proprietary and export controlled information because obviously we know that this is very important from a security perspective, but they really are encouraging states to work together to move science forward. And I think that this is fantastic. One thing about this section that I do not like, though, is that they explicitly release private sector operators from this commitment. And unless they're like operating on a signatory's behalf, but I think why? And what is the story behind this? Why is it that they felt it was necessary to release commercial operators from this section? And I don't really like that, honestly. And I wonder why. I'm curious about it. So if you know something, do let me know. Or if you find an article that talks about this, please send it to me because I've looked and I haven't really been able to find much. I'll keep looking. All right, Section 9, preserving outer space heritage. So basically, I originally thought when I was looking through the table of contents, I thought that it was going to be about properly defining harmful contamination from Article 9 of the Outer Space Treaty. But nope, that's not what this section is about. It's about ensuring the protection of, quote, historically significant human or robotic landing sites, artifacts, spacecrafts, basically evidence of activity. And I can appreciate why this is super important. I really can. It is. I really appreciate why this is important. But I do wish that they had put in more about what it means, what contamination actually means. What do we mean by that? Is it footprints? Is it, a hole that's a certain size? Is it dust in the air? At what point do we say that contamination becomes harmful in the context of outer space? So that's still undefined and still an issue that I think is going to be important. Okay, and now here's where we're getting into some really good stuff. Space resources. Okay, so it notes that space resources can benefit humankind by providing critical support for safe and sustainable operations. And then they go on and assert that space resource extraction can be, quote, executed in a manner that complies with the Outer Space Treaty, end quote. This is very, very, very contentious. So let's talk a little bit more about the 2015 Commercial Space Launch Competitiveness Act. In that act, there is a line that discusses that private companies can, actually, let's just move on to the next page because I talk about it a little bit more. Okay, so in that particular act, Title 4 says that US companies can legally possess, own, transport, use, and sell space resources without violating international law. And the reason that they assert this is because when a company lands on a particular object in outer space, they're not asserting that they own it, they're not trying to appropriate it, they're not occupying it. And so they're not actually claiming that object, but then they go and they dig into it and they extract things from it. And when they take those materials up out of that object, they can then own the material that they have taken out. So that's what this act talks about and says. And in the US, there's a lot of support for this act. In the rest of the world, it's viewed as being very, very contentious. And we'll talk more about that later. It's a big issue. This is a huge issue. And you should know too that there was an executive order that was issued by President Trump, and it's all about encouraging international support for the recovery and use of space resources. And this particular order, the way it is written, it explicitly dismisses the Moon Agreement, which claims that space is a global commons, if you'll remember back to our talk before about that. And basically, by asserting that the moon is a global commons, but if they were to agree that the moon is a global commons, then it would be necessary to set up an international regulatory body to monitor all of the activities on the moon. And we know because the US did not sign the Moon Agreement back in 1979 that they did not want this. And this is, again, so the 2015 Act, the Executive Order, and now the Artemis Accords, all three of those positions have supported the US position that the moon is not a global commons and therefore does not need an international regulatory body to oversee its use. So this is very contentious. And I feel like I'm saying those words a lot, very contentious, yes. Anyway, so it is really huge that they're saying that this is not the case. And I should note too that because this agreement has been signed by representatives from 8 countries in addition to the US, by signing this agreement, all of those nations are basically saying that they support this position, that the moon is not a global commons and that outer space is not a global commons. So this is, again, something that is very notable, and we'll hear more about what the international community has to say about that shortly. Okay, moving on to section 11, which is about the deconfliction of space activities. So basically, they've first established that they are supporting the 2019 paper issued by the Committee on the Peaceful Uses of Outer Space on the guidelines for the long-term sustainability of outer space activities. So, okay, so the Committee on the Peaceful Uses of Outer Space has established some guidelines about what that means. And full disclosure, I have not read it yet. It's on my reading list. I just haven't gotten to it. So stay tuned, and I will go into that one at a date in the future. And then it goes on to talk about affirming Article 9, which is, if you remember that, it requires that states shall conduct their activities with due regard to the corresponding interests of all other states. But now they're changing things up, and this is something new that we have not seen before, and that is requiring that signatories refrain from, quote, harmful interference. Let's keep learning a little bit more about that. Okay. So now they're moving on from this concept of harmful interference, and they're actually talking about the concept of safety zones. And safety zones are defined by the area in which nominal operations could reasonably cause harmful interference. And again, like, they haven't really explicitly stated what harmful interference means, so that's a little bit vague. So there is flexibility there. But they say that the size and scope of these safety zones will be determined by commonly accepted scientific and engineering principles, and that these safety zones will change over time and will be based on national regulations. Now, do you remember that section on reciprocity? So the section in the Outer Space Treaty that talked about reciprocity basically discussed that that all states had to give access to stations, areas to other states, so that they could observe different aspects of activities, and that this access was to be granted on a basis of reciprocity. And so some experts are saying that this concept of safety zones may not be as closely aligned with that concept if it means that some nations may not be permitted to go into these safety zones for certain periods of time. So again, this is something about the Artemis Accords that has some nations a little concerned. We're just wondering how this is going to play out. So, and I don't necessarily, like, we can all understand why this would be important from a scientific perspective, especially if they are doing research that's very important and delicate. But as we see, so they're requiring signatories to respect reasonable safety zones for the purpose of avoiding harmful interference. And they're saying that they're promoting the use of safety zones in a manner that encourages scientific discovery and technology demonstration, but then they also say that it will be for the safe and efficient extraction and utilization of space resources in support of sustainable space exploration. And so we see that this is something that some nations are quite concerned about. But again, like, I can see why this concept would be useful, and I look forward to seeing how it is implemented, and how it is implemented with that, with the article regarding reciprocity from the Outer Space Treaty in mind. So, okay. They do reaffirm the signatories' commitment to respecting the principle of free access to all areas of celestial bodies. So again, I don't think this is necessarily cause for concern, but it is definitely something that I look forward to seeing how it is used. And I hope that it is used responsibly and respectfully by all signatories. And this is cool. Section 12 talks about orbital debris. And orbital debris, this is the first time that this has really been seen in an international treaty, which is something that I think is really cool. So basically, they're talking about how all signatories have to plan end of mission implementation measures to mitigate orbital debris so that space structures are disposed of in a very responsible way. And I think that this is really important, and I really like seeing this. So yay. And then section 13 is about final provisions. And that basically is talking about that there's going to be this periodic review of these principles in the future. And then they also note that the US is going to maintain the original text. And this is very notable that the Accords are not eligible for registration under the United Nations. So these are bilateral agreements. They are between the US and other nations. And they are not going to be submitted to the US or to the United Nations, period. Which is very notable and very important. And again, some nations are a little concerned about why this may be happening. So anyway, okay. So what does the space community, the international space community, have to say about the Artemis Accords? So NASA Administrator Jim Bridenstine is obviously very supportive, and he says that they're vital principles that will create a safe, peaceful, and prosperous future for all of humanity. And then we go on to see US space law professor Christopher Johnson, and he says that the drafters have taken great care to take the applicable international law into consideration, and that these are a set of general principles that all members of the international community can participate in. But this is not actually correct. So those of you who, well, maybe you follow me on Instagram, maybe you don't, and maybe you know, maybe you don't know, but there is this, this particular law from the 2011 Department of Defense Appropriations Act. I think, if memory serves me correctly, it's section 1340, I think. And it explicitly prohibits NASA from collaborating, cooperating, working in any way with China or Chinese-owned companies. And it actually goes even further and says that Chinese delegates are not permitted to visit any NASA facilities whatsoever. So actually, because of that law, China is not permitted to participate in the Artemis Accords and the Artemis Program. Because if they did, NASA could lose its funding. And so this is something that we really have to note. And again, because of that law, we really have to ask ourselves, like, does that put the US in jeopardy of maybe not complying with the reciprocity article of the Outer Space Treaty? Again, like, these are questions that space law experts are asking, and it's a big deal. So yeah, so that law is very important and very contentious. Okay, and okay, so this is changing, and we're going now to hear from Russia what the Russian perspective is. And they say, so Sergei Savelyev, who is the deputy head in charge of international cooperation for Roscosmos, which is the National Space Agency for Russia. He says that attempts to expropriate outer space and aggressive plans to actually take over other planets deter international cooperation in the space arena. So, I mean, this is what he has been quoted as saying. Again, if you're interested in, if you want to know where I got this quote, you can go look for my sources. Yeah, holy smokes. So this is not something that I would necessarily say is like, yeah, totally follows from the Artemis Accords, but this is how officials from Roscosmos have interpreted it. And so then we have to question whether or not it will be effective in maintaining peace in the way that its writers have wanted. Let's keep going. Okay, so this is a Chinese commentator, and he says that the US is developing a new space version of an enclosure movement in pursuit of colonization and claiming sovereignty over the moon. So he's basically comparing the Artemis Accords to British colonialism, again, which is not something that is, again, I think this is a little not quite accurate and a fair depiction of the Accords, but it is stating grave concern, shall we say, for some of the for some of the sections. Okay, and keep in mind too that like China is not permitted to work with NASA at this time. So that's something that maybe they are quite disappointed about. And so then, again, this is from China. By excluding Russia and China, the Accords would encourage irresponsible use of lunar resources and instigate conflicts over lunar sovereignty. Russia is not excluded from signing these accords, from signing the Artemis Accords. They're one of NASA's partners in the International Space Station, and I'm sure that they would be welcome to sign the Artemis Accords. So I call that claim into question for sure. But again, they are questioning whether the Artemis Accords are going to be effective in establishing peace in lunar activities. So again, just to know what the international community is saying. And this is a quote by a law professor from China. And this is a quote that I can actually, understand a little bit more. And he says that a lunar resource extraction framework must benefit all of mankind, and that attempts by the US to, quote, formulate its own laws to allow the extraction of space resources will harm the interests of other countries. And so this is a valid concern, in my opinion, that has been made not just by the Chinese, but by actors in Europe as well. And it should be noted that, like, according to the Outer Space Treaty and all of the other UN treaties and UN resolutions, like, they haven't ever touched on space resource extraction from that perspective, like from an international perspective. And there are other nations that have domestic laws in place regarding space resource extraction, including, I believe, Luxembourg and the UAE. So that's notable. And I think that, yes, if there is no international governing body that is monitoring the extraction of space resources, then I do think that this is a valid concern, or that is something that could harm the interests of other countries. So there we go. Okay, so now I want to talk about why the Artemis Accords are significant. Right? Let's talk about why the Artemis Accords are significant. One of, I think, the most important aspects of the Artemis Accords is that they are bringing up a lot of issues that have not been addressed before, like space resource extraction, like preserving space heritage and orbital debris, and this concept of safety zones, like of ensuring that science that's happening is not interrupted in a way that that would damage findings, or so I think that's important. So I think that there are many aspects of the Artemis Accords that do make them very significant. And then also Frans van der Donk, he has said that he's drawn parallels to the history of air law. And he says that bilateral negotiations and agreements similar to this back between the US and the UK in early air law days, led to larger international agreements in air law, in international civil aviation regulations. And so this is important. Even though these are currently bilateral agreements, they may be expanded at some point. And so this is something to keep in mind, and I think makes them very significant. They also, I think, signify or signal that there are going to be changes in space governance. Basically, we've never seen anything like this before, like using a bilateral agreement to dictate norms, and those norms, like signing on to them, is a condition of being involved in a space program. This has never, we've never seen anything like this before. So I think that's really significant. And then another thing too is that these accords, because they are bilateral agreements, they can be executed very quickly. And if we think about that timeline that has been proposed for the Artemis program, it's a really fast timeline. Like, things are going to be moving quickly. And one downside of the United Nations is that it takes a long time to put agreements through the UN. when you're consulting so many different members. So this is definitely an advantage of the Artemis Accords that does make them very significant, in my opinion. So I would love to hear what you have to say about that. Yeah, so okay, and I guess you can anticipate what some future issues are going to be. I think we're going to see more development to do with laws regulating private companies. I'm hopeful that there will be some sort of international regulating body to do with space resources at some point in the future. What else do you think would be a current issue? Maybe seeing orbital debris mitigation being again in larger treaties. So those are, I think, some very real issues. And also I would love to see that, that issue of harmful contamination addressed more specifically. And then I'd also love to hear more about what specifically benefits are of space. I mean, so there are a lot of great websites, including the UN Office for Outer Space Affairs, that does talk about the benefits of outer space for all people. I totally recommend you going to check out their website. It's really fantastic. NASA, other organizations also have websites that talk about this very frequently, and there are so many benefits of outer space exploration. But I would love that to be more clearly defined at some point. And I would love peaceful purposes to be clearly defined too at some point. But again, we know that defining things clearly may make them less agreeable or more difficult for nations to get behind. So yeah. And then also too, like that that issue of property law and appropriation and occupation, that is something that definitely needs to be addressed too in a future issue. So at a future point in time. Okay, so with that, let's go for some questions. Now, thank you so much for submitting questions in your sign-up documents. And if you do have any other questions, please pop them into the chat box and I'll get to them. Okay, so I'm just going to go through these questions that you submitted. And if you're watching this on YouTube at a later date and you do have questions about any of the material, you can definitely get in touch with me via spacecodehacker.com, or you can find me on Instagram at spacecodehacker. I'm very active there, so come say hi. Basically, okay, so we're going to dive into these questions. And the first one is, how should we avoid and resolve legal political conflict with countries who don't follow international agreements, and who enforces resolutions and how? So as we know, resolutions are non-binding according to the International Court of Justice. And if there were some sort of conflict between nations to do with the Outer Space Treaty, then those would go through the International Court of Justice. And then in terms of the Artemis Accords, I'm actually not sure. I don't know. And this is a great question and one that I will have to look up. So I don't know. Again, I think that like the Artemis Accords, they are non-binding. They represent political agreements. So I don't know if there would be any organization to enforce those principles. I'm not sure. Like for contractual mechanisms for contracts between nations and private companies, those would just be, I think those would just be like enforced by like national laws, national judicial systems. But yeah, I don't know. That's a good question. Something to learn about in the future. At some point, there will be commercial exploitation of lunar surfaces. How does space law address ownership of these resources and therefore the ability to sell or trade them? So again, there are lots of countries that have laws about space resource extraction, the US being one of them, as we've discussed. Yeah, and so there are laws about how they can own these resources, and they're very contentious. And yeah, I feel like this question was acknowledged or discussed fairly well. Yeah, is there a justice system in place? For example, if a crime was committed, how would astronauts react and take initiative? Again, I think it would probably go through the International Court of Justice. Okay, next question. This is one I love. If I'm not great at physics, but I love astronomy, is it still possible to work in the outer space field? Yes, absolutely. The great thing about outer space is that literally everyone will be needed. So no matter what your strengths are, I believe that there is a place for you in space, in the space industry. So, even if you love marketing or communications or what would I say, like anything else, human resource management or digital graphic design, anything like that. Those are all skills that are really needed. So artists are needed in the space industry, absolutely. And communicators, people who are great at taking very dense scientific material and communicating it in a way that is understandable to the public. Like that's a really important skill in the space industry, especially because funding comes from the public. So that's huge. So I strongly believe that no matter who you are, no matter what your skill set is, if you are passionate about outer space, then you should go for it. Like go for it and get that career that you dream of. There's this quote from one of my kids' favorite books. This book is called May Among the Stars. And one of the quotes from that book is, if you can dream it, if you can believe it, and if you, well, I shouldn't say can, if you dream it, if you believe it, and if you work hard for it, anything is possible. So yes, you can totally do it. Okay, how did I get interested in space? So I saw my mom watching the 1997 movie with Jodie Foster in it called Contact, that's based off of one of Carl Sagan's books by the same name. Oh, and I was hooked. After seeing little snippets of that movie, I probably would have been like, I don't know, maybe 10 or 11, something like that. I was just fascinated with space exploration and I read prolifically. And I actually started off as an astrophysics major at university, but ended up switching to math later on. My brother's doing a PhD in astrophysics. So this is something that's very much a part of my family culture. Just something that I really love and I'm super, super passionate about. Like me and my husband were always watching launches and keeping up on space news. My kids are running around in astronaut costumes all the time. Like this is something that we spend a lot of time talking about. We love looking at the stars and wondering about what's out there. So I'm very passionate about it. Any advice for high schoolers interested in space? Important skills we need to learn. Oh my goodness. I think that just having passion is really important. Having passion and being curious is super, super important. So I would say just go for it and try to learn about topics that you know nothing about because you have no idea how much it will shift your perspective in a big way. So yes, keep working. You can do it. Believe in yourself because you belong. Whoever you are, whatever your background is, whatever your preferences are, you belong. You belong in the space industry and you belong in STEM or STEAM, however you want to say it. Can we buy or sell land on the moon or Mars or in orbit? No, not right now. It's not subject to national appropriation, although, like I said, some private companies could theoretically claim if they wanted to. What advice do you have for someone currently studying law, but also wants to be involved in aerospace? So I'll share my plans with you. When I do eventually get to go to law school, I plan on focusing on international law and dabbling in constitutional law as well. And then my plan is to specialize in space law for my advanced law degrees. So like LLM and PhD after I've got my original like JD MPP program. So yeah, that's my plan. I definitely think that if you want to be involved in space law, it will be very necessary to get advanced degrees to specialize. And if you're interested about the different programs that are available, like I said, go check out my website because I'm trying to keep a full list there. Okay, what is most lacking in current international space law? I think we've covered this fairly well. Let me see. All right, I think that those are pretty much the questions that we have. And then let me just go to the chat and see if there aren't any more. Okay, so there we go. Thank you so much. Okay, so let's talk a moment about my sources. So I've listed all of my sources here in this document, but if you want to access links to them, so you don't have to just like go and search all these words, I totally recommend that you go to bookshelf.com, and that's bookshelf without an E, or you can download the Bookshelf app. It's a fantastic app. I totally recommend it. And when you do go to that website, you can search for Lauren Killam or Space Code Hacker under curators. And then when you click on my name, you will see my shelves. And you can click on my space law shelf. And that is where I save every single article, document, anything that I can find about space law. That is where I put it. So if you're, and that goes for all of these sources as well as reading in the future. So if you ever want to know what I'm reading, that's where you can find it. So I definitely recommend that you go check it out. And oh my goodness, there are so many other amazing people on Bookshelf as well. Kate Gunderson, Camille Caballero, I'm pretty sure is her name. There, oh my goodness, Tanya. Oh my gosh, she is just so fantastic. So yeah, yes, I definitely think you should go to bookshelf.com. There are so many amazing. Tanya Harrison, I didn't say her last name, sorry. Oh my gosh, there are just so many wonderful people on bookshelf.com that you should go and find, go follow their bookshelves, because if you ever want something to read, my goodness, you will find it there. Okay, and so thank you so much for joining my webinar and tuning in with me. Come and say hi to me on social media, and definitely get in touch if you have any questions about this. I'm more of an enthusiast and less of an expert, but my gosh, I love talking about it. So come have a chat with me. And thank you so much for tuning in. And there we go. So thank you very much, and back to you, Carolina.
Thank you so much, Lauren. That was an incredible webinar. I learned so much from it. And thank you everyone for coming. I hope you got something out of this and you're encouraged to attend our events in the future. Please make sure you fill out the swag form so we can get your swag to you. And here are some of our upcoming events that we'll have in the future. The dates are not determined for these yet, but we'd love to see you at both of those. When the signups do come out, you can subscribe to our mailing list to get an email update, and all the information, as always, can be found on girlsinaerospace.org/events. Make sure to also follow us on Instagram at Girls in Aerospace to get regular updates about what we're up to. Again, thank you for coming. We loved having all of you here, and we hope to see you soon.